And that was my job. I think I was the scribe.
Okay, let's move on. I'd like to go to the Heller case. When we met in my office, we discussed the Heller decision, which you said you were open to discussing since the case had been decided. At that time, you said you thought both the majority opinion written by Justice Scalia and the dissent written by Justice Stevens were brilliant examples of originalism, where both justices sought to explain the reasoning by looking at the original public meaning of the Second Amendment. Which decision did you agree with and why?
Well, Senator, I think we've alluded to my difficulty here. I do think everything you've just said is accurate. Both Justice Scalia and Justice Stevens wrote excellent opinions in that case. I am not here, though, to grade my boss's work. That would be kind of impertinent of me, I suspect. And certainly I'm sure they would think so. I also worry that saying I agree with one or the other will indicate to clients or to litigants in future cases, because it's now a precedent in the United States Supreme Court. It's binding. It's the law, whether we like it or not. It's the law. And if I start saying I like one opinion or I like the other opinion,
all right,
I'm signaling...
I'll let you off the hook.
Oh.
Let me go to another one.
Thank you, Senator.
In D.C. v. Heller, the majority opinion written by Justice Scalia recognized that, and I'm quoting, "Of course the Second Amendment was not unlimited," end quote. Justice Scalia wrote, for example, laws restricting access to guns by the mentally ill or laws forbidding gun possession in schools were consistent with the limited nature of the Second Amendment. Justice Scalia also wrote that, quote, "Weapons that are most useful in military service, M16 rifles and the like, may be banned," end quote, without infringing on the Second Amendment. Do you agree with that statement, that under the Second Amendment, weapons that are most useful in military service, M16 rifles and the like, may be banned?
Senator, Heller makes clear the standard that we judges are supposed to apply. The question is whether it's a gun in common use for self-defense, and that may be subject to reasonable regulation. That's the test, as I understand it. There's lots of ongoing litigation about which weapons qualify under those standards, and I can't prejudge that litigation.
No, I'm just asking you, do you agree with his statement? Yes or no?
Are the statements out of the Heller decision from the United States?
Justice Scalia's statement.
Well, whatever's in Heller is the law, and I follow the law. Well, it's not a matter of agreeing or disagreeing, Senator, respectfully. It's a matter of it being the law. And my job is to apply and enforce the law.
All right, fair enough. Let me give you another one. The Fourth Circuit. Judge Harvey Wilkinson authored a separate concurrence in the Fourth Circuit case, Colby v. Hogan. Here's what he said. "No one really knows what the right answer is with respect to regulation of firearms. I am unable to draw from the profound ambiguities of the Second Amendment an invitation to courts to preempt this most volatile of political subjects and arrogate to themselves decisions that have been historically assigned to other, more democratic actors. Disenfranchising the American people on this life and death subject would be the gravest and most serious of steps. It is their community, not ours. It is their safety, not ours. It is their lives, not ours." Do you agree with Judge Wilkinson that the Second Amendment is ambiguous? If so, should the ambiguity be decided by the courts or by legislatures?
I'd begin by saying I hold Judge Wilkinson in high regard. He's a very fine man and a very fine judge.
Can you do yes or no?
No, I wish I could.
I wish you could, too.
But, you know, the Supreme Court of the United States isn't final because it's infallible, as Justice Jackson reminds us. It's infallible because it's final. And Judge Wilkinson had his view, and the Supreme Court has spoken. And Heller is the law of the land, and Judge Wilkinson may disagree with it, and I understand that. And but he will follow the law no less than any other judge in America. I am confident of that. He's a very fine judge who takes his oath seriously.
Okay. I asked you that question on super precedent, and let me end with one on workers' rights, if I might. As you know, there have been a number of Supreme Court cases where the court has made it harder for workers to hold their employers accountable when they have experienced discrimination or be injured on the job. And we've discussed that one case, Trans Am, I think 3 or 4 of us. Let me give you a short list. Ledbetter versus Goodyear Tire, which limited the ability of women to seek equal pay. Gross v. FBL Financial Services, 2009, which made it more difficult to prove age discrimination. And the University of Southwest Texas Medical Center v. Nassar in 2013, which made it more difficult for employees to prove they've been retaliated against for reporting discrimination, including based on race, gender, national origin, religion, and other factors. Vance v. Ball, which made it more difficult for workers to prove just plain discrimination claims. As Senator Whitehouse pointed out, each of these cases was 5-4, and Justice Scalia voted with the majority against the employee in every case. President Trump and others have said, you are the next Scalia. So I think it's only fair to ask you, do you disagree with any of the majority opinions that Judge Scalia joined in these cases? If so, which ones do you especially disagree with, and why? These have already been decided.
I understand, Senator. But again, if I indicate my agreement or disagreement with a past precedent of the United States Supreme Court, I'm doing 2 things that worry me sitting here. The first thing I'm doing is I'm signaling to future litigants that I can't be a fair judge in their case, because those issues keep coming up. All of these issues, as you point out, keep coming up. Issues around all of these precedents will continue to be litigated and are hotly litigated. I've had post-Ledbetter Act cases in my court, for example.
Then how do we have confidence in you that you won't just be for the big corporations, that you will be for the little man? This is the question that Senator Hirono, I think, so well asked yesterday. You know, those of us, I think, on both sides care very much about workers' rights, but the record is such that one questions whether the court is capable in its present composition to give a worker a fair shot. So I'm just looking for something that would indicate that you would give a worker a fair shot. Maybe it's in your background somewhere that I don't know about, but I'd like to have you respond to it any way you can.
Senator, I really appreciate that. And I think there is a way you can take a look at this question without me potentially prejudging a case. And I appreciate your respect for that. And just to finish that thought, I'm concerned that I have to look the litigant in the eye in the next case. And if I prejudge that case, they can look at me and say, you're not a fair judge. And I've got no answer for that. I've got no answer for that. So what I think can give you comfort in this area is, Senator, I know a case or two has been mentioned yesterday. Respectfully, I'd suggest that does not represent the body of my work. I've participated in 2,700 opinions over 10 and a half years. And if you want cases where I've ruled for the little guy as well as the big guy, there are plenty of them, Senator. The Ute Indian tribe.
Would you be willing to submit some of them?
Oh,
it's
goodness.
hard to read 2,700 cases.
I'll name a bunch of them right now.
On Trans Am.
I'm sorry, Senator. Of course. Ute 5 and 6, Fletcher, the Rocky Flats case, which vindicated the rights of people who had been subject to pollution by large companies in Colorado, uranium pollution. I point you to the magnesium case, similar pollution case in the Salt Lake City area. Colorado's effort with renewable energy upheld that. Or versus City of Albuquerque, involving pregnancy discrimination in the police department in Albuquerque. WD Sports, a discrimination claim. Casey, Energy West, Crane. Simpson versus CU, involving young women who had been harassed by the football team. AM versus AM, Browder, Sutton. I can give you a long list.
And we'll find them and we'll read them.
And Senator, the bottom line, I think, is that I'd like to convey to you, from the bottom of my heart, is that I'm a fair judge. And I think if you ask people in the 10th Circuit, is he a fair judge, you're going to get the answer that you got yesterday from both Senator Bennett and Senator Gardner and from General Cotchiel, and the same answer you got from Senator Allard and Senator Salazar 10 years ago. And Senator, I can't guarantee you more than that, but I can promise you absolutely nothing less.
Okay, I have a minute and 21 seconds. Let's talk Chevron. That's been used, thousands of times, and it really perplexes me. Olympia Snow and I did something that took me 12, 13 years to get to, and that is changing the corporate fuel economy standards. And thanks to Senator Inouye and Senator Stevens, they put it finally in a commerce bill, and it passed. So now we are on our way to 54 miles a gallon. Here's the point. We could do the rules for the first 10 years, but who knew we needed the experts to do them from that point on? So what we said in the legislation was that science would prevail. And that's still the law. It's working. The goal is, I've read articles, they say there'll be 54 miles by 2025 if this continues. What is wrong with that? How else could we have done it?
I'm not aware of anything wrong with that, Senator. I've never suggested otherwise.
But what you said is the Congress could not legislate by leaving some of the rules up to the scientists or other professionals in departments, as I understood it, in Chevron.
I appreciate the opportunity to correct this misunderstanding,
Sure,
Senator.
Appreciate it.
The case I think you're referring to is Gutierrez.
That's correct.
It involved an undocumented immigrant to this country. Okay. And the question was, there were two conflicting statutes. One said he could apply for immediate discretionary relief in this country from the Attorney General. Second said he had to wait outside the country for 10 years. We had a judicial precedent that said the first statute controls. That was the ruling of our court. After that, 3 or 4 years, I can't remember exactly, the Board of Immigration Appeals, in its infinite wisdom, says our interpretation is wrong. Chevron. You have to undo your precedent, the judicial precedent, that this man had relied upon, and that he now had to wait outside the country not just 10 years, but 13 or 14, because it took them so long to make up their mind. Well, Senator, that reminded me of, when Charlie Brown's going in to kick the ball, and Lucy picks it up at the last second. And that struck me as raising serious due process concerns, fair notice, and separation of powers concerns, when an executive bureaucracy can overturn a judicial precedent without an act of Congress. That's what the case was about. And it suggested, respectfully, Senator, that under the APA, the Administrative Procedures Act, this body tasked judges to decide legal questions and left to administrative agencies great deference when it comes to fact-finding. Okay? That's how I read Section 706, is fact-finding by scientists, biologists, chemists. The experts get great deference from the courts. The only question is who decides what the law is. And can a man like Mr. Gutierrez, the least amongst us, be able to rely on judicial precedent on the books, or can he have the ball picked up as he's going in for the kick?
I think I've exceeded my time.
Oh, I'm sorry.
Apologize. Thank you very much.
I apologize.
Thank you.
I want to make clear to everybody that you didn't exceed your time because I said if you asked your question before the last second,